I'm DeDe Soto with the Soto Law Group, and a little bit about me. Everyone calls me DeDe, but my legal name is actually Romelia. I was named after my Cuban grandmother, and I am local grown here. Went to Cal State Fullerton, then Western State, and some continuing ed at Chapman University School of Law as well. That's where I began my passion for estate planning and have never looked back. So we just focus on estate planning, trust administration, trust disputes, conservatorships, special needs trust, probate, and child protection plan. We want to protect those minors. So questions you really need to ask yourself. Why do I need to have an estate plan? What is this probate all about? So do you own a home? It doesn't matter if you have a home that's worth $1 million and you have a line of credit, or your mortgage is due $990,000, or if you have a home that's $500,000 and you owe $500,000. If you own a home, you really need to plan, right? Do you have investment accounts, brokerage accounts, retirement accounts? Do you have life insurance? Do you have a rental property? Do you need to protect that? Do you have a vacation home? Are you going to receive an inheritance? Do all of these assets add up to a total of 184.5? If you answered yes to that question and you have nothing in place, guess what? Your estate plan is called probate. It's really not a pleasant process. And yes, we go through probate. We can assist you through probate. We do trust litigation and probate litigation, but it's best to stay out of it because it costs a lot of money. It's a lot of heartache, and it's time consuming and can be very frustrating as well. What is probate and why do you want to avoid it, right? I'm sure you all have heard probate. Oh, it's just an awful process. It's slow, it's expensive, and all of the above are true. It really is slow and expensive. The threshold is that 184.5. I know it sounds crazy, and I don't know how they got to 184.5, but it's been adjusted for inflation. It used to be 150,000, and it's just gone up from there. So probate is the process that we determine who your natural heirs are and how to transfer the assets to them. And your natural heirs might not be the people that you actually want to receive. There could be unintended consequences if somebody dies and it goes to nieces and nephews and or stepchildren, right? You just never know. And so that's why you really want to avoid probate, because otherwise, if you have your estate go through probate, the court directs who is going to take what. They direct if it's going to go to your spouse or not, or to your children or not. And it depends on the type of asset. And it can take months and even years to settle. It used to be that probate only took 1 year. Now I'm quoting 2 years. And it's through COVID, that's when it really increased from the 1 year to the 2 years. So you really want to try and settle it prior to going to probate, right? You want to do a little bit of planning and then you can avoid probate. So it can cost, it's not just court filing fees, it's creditors get to be paid first before your beneficiaries, taxes that are owed, and yes, there's attorney fees because it does take a lot of work to get through the probate process. What is this probate process? It's so convoluted, and this diagram that we have is very convoluted, absolutely, as it should be, right? So it's a process. How does it all get started? Well, you have to open up probate. So somebody dies with assets in their name alone, whether they have a will or they don't have a will. A will does not avoid probate. If you leave this webinar only with one item in your head, I hope it's that a will does not avoid probate. In California, other states could be different, but in California, a will does not avoid probate. So whether you have a will or not, you're going to probate. And if it's 184.5 or more, that's when it goes through probate. There's other petitions and actions that you can do if it's less than 184.5, okay? So you file this petition and then somebody has to be appointed. That's the executor or the administrator, right? And that depends on if you have a will or if you don't have a will. So it depends. Then they have to collect all the assets, and it's assets that have no beneficiary. If you have a retirement account and there's a beneficiary, it does not go through probate. That's why you have to make sure all your ducks are in order, right? If you have a brokerage account and you have a designated beneficiary, same thing, it doesn't go through probate. But if there's no beneficiary, it's going to go through probate. So we collect all the assets, right? And collecting all the assets so that the probate referee can make an appraisal of all these assets. If you have a home that was in your name when you pass, it has to be appraised. Bank accounts, family heirlooms, personal property, all of that has to be appraised. And then that's how they determine, what does your probate estate look like? Is it 2 million? Is it 500,000? Is there a house? Is there no house, right? Then it goes through this long process, and then all the bills get paid. Creditors can file claims. A creditor can actually open up probate. If you don't pay your debts, a creditor can open it up. So it's a process that takes 1 to 2 years, period, into the discussion, and that's if it's not being litigated. If it's being litigated, it can take 4 or 5 years. We are in a probate process right now that we have not been able to close it out, and we're going back about 4.5 years. I think when it's all said and done, it's going to be a process of 5 years. You know, you've lost a loved one. You want to close the estate. You want to close this and remember them, but not have to be dragged through the probate process. So here's the probate. This is how the fees get calculated. This is how the executor gets paid. This is how the attorney gets paid, right? Here we have it. It's all based on the fair market value. It's not your equity. It's the fair market value. So as you can see, there's some numbers here on the right. If you have a minor child, you cannot leave assets to a minor without going through probate and getting a guardianship. So that's life insurance. Doesn't have to go through probate if you have a beneficiary, but if you have a beneficiary and they happen to be a minor, it is going through probate, okay? Retirement accounts, they forgot to name a beneficiary. Your stocks, bonds, brokerage account, forgot to name a beneficiary. So all of that adds up and it's probate. So if you look at this, 2.73, nice little nest egg. I suspect that would get a couple kids through college, right? Even in today's dollars and cents. But look at this. $135,000 in probate fees alone. So that gets taken off the top, and then the balance of it will go to your heirs. Not a nice process, right? And if I was to tell you, you could do a trust and a will and all your documents for a fraction, you know, somewhere around $4,000, you can get everything in order. That's a lot less than $135,000. So what's the next process? Here we go. This is what I love to talk about. The 5 essential documents you need to protect yourself against probate, especially if you have minor children, right? So the first is a will. But if you have a will, do you have to have a trust? Absolutely, to avoid probate. Then if you have a will and you have a trust, then you also need a financial power of attorney. And if you have a financial power of attorney, do you need healthcare documents? Absolutely, right? And of course, if you have minor children, you absolutely have to name guardians. And that's where we come in. And each and every one of these documents actually serves a specific purpose. And together they all speak to each other and they protect your legacy. No one wants to leave a legacy that has to be litigated. So what is this thing called a will, right? And is there really a reading of the will? No, that's only in the movies. This is just one of my favorite pictures. It is the reading of the will, but it's with all the assets. And I think in this particular picture, everything goes to the dog. And all of the greedy beneficiaries are waiting to hear what they are going to receive. The reading of the will doesn't really happen. No, it goes through probate. That's the reading of the will. So it describes who you want to give things to, but it doesn't hold title. And so this is just the probate process. You can say, I designate, I'm going to give my car to my niece. I'm going to give my house to my sibling. I'm going to give my brokerage account to my mom. I'm going to give my bank account to my friend, right? So you can allocate and designate who you want to give these assets to. But at the end of the day, it has to go through the probate process if you only have a will. And that's what we're going to try and avoid. Let's see how we can make things better so it doesn't go through the probate process, right? No reading of the will. So that is through a revocable trust. And a trust is a document It's like a legal entity, but it's really not a legal entity. But it's a document that you do as the grantor, as the owner of all of your assets. And within the trust document, you transfer title into it. It avoids probate. It keeps your affairs very private. It preserves your legacy for future generations, possibly, depending on what your assets are worth and how they're managed as it goes to future generations. But guess what? A revocable trust avoids probate if it's done correctly and if it's funded. So, how does a trust get funded, or how does it get done correctly? So, for instance, funding your trust. You prepare a trust and you say, I'm the grantor, I'm the owner, and I am going to leave these assets to my children and my nieces and nephews. So the trust document will state how your assets get divided when you pass. And it says, if I become incapacitated, how will someone manage my assets? Who will step into my shoes if I'm one, incapacitated, or two, after I die? Someone has to conduct this process. So we have a house, we have a deed, title is in your name. Well, we have to transfer it to the Soto Revocable Trust, not your assets, but my assets. So I have a house, I have a deed, I'm going to prepare a deed, and it's going to go into my treasure chest, which is my trust, of which I am in charge, right? So that's funding your trust. You have a life insurance policy. You're going to make the trust the beneficiary because your treasure chest holds title to your trust. And if you see, that's the difference between a will. A will does not hold title, but a trust will hold title. And someone steps in, and if you become incapacitated, someone's going to make sure that your bills are paid, food is in the refrigerator, right? If your kids are going to college, you're going to make sure that college is being paid, right? It's a document that continues to exist even though you are one, incapacitated, or two, you have passed. But there's a process, and you have to make sure that it gets funded, right? And funded is either transferring the asset into your treasure chest, i.e., your trust, or it is making sure your trust is the beneficiary, depending on the type of asset. And all assets, they're a little bit different, right? So you have to go through and see. There's trust, there's other bells and whistles that you can make sure that your kids don't receive it all outright at 18. You can say, I'm going to give it to them at ages 25, 30, 35. I want it to pay for college. I want it to buy a fair and reasonable car. All of your values can go inside your trust. Now we're going to shift to the other document, a durable power of attorney. Remember, these documents are not just if you are dead. These documents are if you are alive as well. And all of your assets should benefit you. So what does a durable power of attorney do? It allows someone to manage your assets if you are incapacitated. And when I say incapacitated, it's dementia, it's Alzheimer's, it's cognitive loss, right? Without a designation, without a power of attorney, guess what? Your family has to go to court and get appointed to be a conservator over you, to be able to manage your assets. Then they have to do an annual accounting. They have to do an accounting that shows what they have spent every dime for. And this has to be done until you die. So it's managed by the court system. Spouses, parents, children do not have automatic rights to assist in the financial affairs of a loved one. It has to be documented. Okay, so the power of attorney allows them to get access to your 401k, not to go on a cruise with your money, but to pay your bills, to make sure you have your caregivers are being paid, right? That's what the power of attorney does. Then, of course, healthcare directives. Everyone that's 18 or older needs to have these three documents, in my opinion. It's the Advanced Healthcare Directive, which is end of life decision, life support, no life support, organ donor, no organ donor. Healthcare power of attorney authorizes the names, designated that who's going to make healthcare decisions for you, who's going to hire and fire staff, who's going to care for you. And then, of course, the HIPAA release, right? The HIPAA is the privacy. Dealing with insurance company, making sure that your medical bills are getting paid if you're incapacitated. And then, of course, managing your remains after you pass, making sure that your wishes are carried out. Remember at the beginning, we said also guardians, right? So if you have minor children, you absolutely have to name guardians. We like to call it our child protection plan. We like to have short-term guardians and long-term guardians, right? Because accidents can happen. You can be going down the freeway, you get in a car accident, your minor children are in the car, you're rushed to the hospital because you're unconscious. You're going to be okay, but who's going to come and take your kids? In the state of California, actually throughout the United States, you cannot release physical custody of a minor child without parental consent. So this is what we do. Short-term guardian, someone that lives within 30 minutes that can get to your children really quickly. You give them, as the parent, you give your mom, dad, brother, sister, aunt, uncle, or a neighbor, friend, the authority to take physical custody of your minor child until the long-term guardians can get there or until you regain consciousness and you're released from the hospital. Otherwise, CPS steps in, and that's Child Protective Services, which is foster care. Not that it's a bad thing, but it could be a scary place for a minor young child to be. And it doesn't matter if they are 17 months or 17 and a half. If there's an accident, you cannot release physical custody of a minor child, and a minor is up until 18th birthday without parental consent. So that's where we step in. Then if you do not have guardian's name and the unthinkable happens, mom and dad are both killed, then the court will decide who's going to raise your children. And it's based on who comes forward, who says, I'm supposed to raise, I'm the auntie, I'm the uncle, whatever it may be. So I don't know about you, but I think I would rather name the legal guardians instead of relying on the court system to decide. And again, this is the short term without a plan. Your loved ones, your minor children could end up in foster care instead of having a temporary guardian. So without a long-term plan, this crazy looking judge, like I said, is going to make the decisions for you. And you might not like them, right? You might not like the decisions that are going to be made or who's going to come forward and say that they will raise your children. This is one of my favorite slides as well, next to the will. Procrastination's a silent killer of estate planning. We're in a case currently where changes should have been made, changes were not made, and now someone is incapacitated and no changes can be made, right? If you do not have the cognitive power to make decisions for yourself, someone can't go in and make changes on your behalf. So I always say it can never be too early to do an estate plan, but it can be too late. So don't procrastinate. That's why we do these educational workshops. We want to encourage you to plan sooner rather than later. And again, we are here to support you and assist you to make sure that your wishes will be carried out and your family can avoid probate. If you would like to have a consultation, you do have to fill out some paperwork, and Anita from our office will get back to you. We just need to know, do you own a house? Do you have minor children? Do you have rental properties? What are you trying to protect? Are you married? Are you single? Do you have a prenuptial agreement? Do you have a postnuptial agreement? All of this plays into your trust planning, and you want to make sure that it's done correctly. And I always say that, yeah, it's going to cost a little bit, but the price is pennies on the dollar compared to not planning. We have plans that start around $4,000 and go up for married couples. So it just all depends on what your needs are. But I just want to say that it's better to plan. And the only thing that is consistent in life is change. So with that, I hope I see you soon. And if you don't use us, please make sure that you get something done. So we'll open it up to questions.
I have a question for you. As far as setting up any of this, are there monthly, annual maintenance fees, or is it kind of a one-time, set it up, pay the lawyer, and then it's just, there you have it?
It is a one-time, pay the lawyer to get all your documents in order. Now, if there has to be modifications or changes, then yes, you have to pay for those modifications or changes. But it's not a monthly fee or annual fee or anything like that. It's just based on the changes that you have to do.
Gotcha. And I'm sorry, one more question. At what point do you believe this estate planning becomes pretty important? I know obviously the answer is going to be as soon as possible, right? But if my wife and I, we don't currently hold a lot of assets and we're just planning for the future, I don't want to be overdoing it by setting up a trust when we're just trying to build a savings account right now. So,
Right. No, I understand that. And so like I said, the 184.5 is the threshold. But what you need at a minimum, we call it a mini EP plan. That is, you need your healthcare documents and you need your durable power of attorney, just in case there
right.
was an accident, in case somebody needed to assist you. In my belief, those are some of the documents you need starting at 18 years old, right? Because as soon as you turn 18, your parent
Right.
has no authority to make any medical decision or financial decision on your behalf. You can start with the powers of attorney and your healthcare directives without setting up your trust or your will. So yeah,
Got
you can say, okay, I'm going to start with this. I think my youngest client that actually set up a trust and a will, durable power of attorney, she had received an inheritance. She was 25 years old and she actually was very prudent. She obviously lost her mom at a young age and had to go through the probate process. And she was like, this is not happening. And all of her assets were going to her friends. And she tells me
oh,
the
wow.
story that she was asking her friends, "Will you step in?" And their friends are like, "Are you sick? Are you okay?" "I'm fine. I'm being prudent, right? I'm taking care of business." So yeah, can it be too late? Absolutely. Can it be too early? No, it cannot.
So just to reiterate, make sure I'm absolutely hearing this 100% clear. Powers of attorney, very important. Absolutely should take care of those. And then if what we currently have is under 185 grand, I'm not going to say there's no point, but 185 grand is where it starts to get a little dangerous.
Yeah, 184.5.
184.5. Perfect. That's all I need to know. Thank you.
Absolutely. Thank you. Yeah, a pour over will and a testamentary trust. Oh, goodness. I feel for you. I'm not sure what the question is, but you had to go through probate and maybe you were the beneficiary of the testamentary trust. Then the terms of the testamentary trust kick in, and that's what has to be managed. And I don't know what the testamentary trust says, but it can say various different things. And so it has to be followed. And it depends on, does it say court monitored or non-court monitored, right? So yeah, we don't like to do testamentary trust. We like to do trust, standalone trust, so it's not a testamentary trust. But yes, there is a such thing, and it depends on what that testamentary trust says. Oh, no court. Okay, great. So yeah, if you need assistance in administering that testamentary trust, we can assist in administering the testamentary trust. Great. I hope I answered that question for you. All right. Well, you guys had some good questions.
I have another one if none are coming through.
Certainly.
Okay, so there's this idea that you can place your assets in a trust, and in the event that something bad were to happen, that you wouldn't have any ownership over things, so people couldn't come after you. Let's say, for instance, I have a trust, I have my vehicles in my trust, and I were to get into a horrible accident that I was at fault for, and somebody wanted to come after me for my things, because my assets are possessed by the trust, they don't necessarily have access to any of that. Is that
You have half correct and half incorrect. First of
okay?
all, we would never put a car inside of a trust. And second of all, revocable trusts are not asset protected. You would have to do an irrevocable trust if you were truly trying to protect $1 million from lawsuits, etc. So revocable trusts are pass through. They are not asset protection. If you get in a lawsuit, they can come after your assets. If you do an irrevocable trust, that's where you have the assets protected. However, you are giving up control and you are not 100%. You're really not the owner of those assets any longer because you have release control in order to have asset protection. And it's above and beyond estate planning 101, but I did want to address that. Okay.
Okay, gotcha. Thank you.
Fantastic. Well, I have enjoyed this session and I love answering questions. I encourage you all to plan. If you're not ready to do a trust and a will, at least do your durable powers of attorney for your finance and for your health care, because the worst is if somebody has to go and get a court order to make healthcare decisions or financial decisions for you when you do have those assets. Goodness, I do have one more question I just saw. What happens to a trust during the process of divorce? Okay, as soon as you file for divorce, everything gets frozen. After you get through your divorce, then you can separate things and according to the court order, because at the end of the day of your divorce, it'll say, he gets these assets, she gets these assets, and then whatever assets are your own, then you can put them in a trust and protect yourself and your family. But everything is frozen during the divorce process. Well, thank you so much. Look forward to hearing or seeing you in person or back on Zoom. Take care, everyone. Bye-bye.